Welcome to the Administration section of the Oregon Secretary of State's online notary education course. In this module, we will discuss what a notary is and what it takes to become a notary in the state of Oregon. Notary commissions are effective for 4 years. You can reapply for a new commission 2.5 months before your commission expires. Give yourself plenty of notice to get your renewal done. If your commission expires before you are recommissioned, you'll need to take the training again. A notary is a person of proven integrity who has been appointed by the state of Oregon to act as an impartial witness. One of the components of being a notary is integrity. When you fill out and submit the notary application, you're giving the state permission to run a criminal background check. The public needs to be able to rely upon your integrity. Your notarization serves as admissible evidence that an act took place. Your customers need to know that when you notarize a document for them, it will remain confidential. You do not want to breach their trust in you. In these ways and more, the state of Oregon is depending on your proven integrity. If the notary public happens to also be a public employee, their journal is considered a public record. This does not mean that anyone can request a copy of their journal, but may request a copy of a particular journal entry with just cause. Notaries act as an officer of the state while performing their duties as a notary public. As a state officer, a notary needs to follow the laws and rules that govern notarizations. Oregon notaries public may only notarize within the state of Oregon. They may notarize documents from outside the state, but they have to physically perform the notarization within the jurisdiction of Oregon. If you perform notarizations as part of your job, you need to remember you are commissioned by and represent the state, not your employer. Notaries are not allowed to issue apostees or authentications. The notary is also acting as a neutral third party when performing notarizations. The notary public is an impartial witness to the transaction. The notary may not notarize for their spouse, and although Oregon law does not prohibit notarizing for other relatives, it is prudent not to do so. It is easy for a court to construe that a notary may gain from a transaction with relatives. The notary or their spouse should have no financial interest in the transaction and must not be named in the document. The notary should have nothing to gain by the notarization. Otherwise, suspicion of fraud is thrown upon the whole proceedings. A notary may not notarize their own signature. A notary may not perform a notarial act if the notary is a signer or named in the document to be notarized. The notary must determine willingness and competency of the signer. If there is any doubt, the notary should request a determination by a physician or attorney as to the ability of the assigner to understand and make decisions. When the notary changes their name or address, the notary has 30 days to notify the Secretary of State. If a notary is a non-resident of Oregon and their Oregon place of employment changes, the notary has 30 days to notify the Secretary of State as well. As a notary, you are responsible for knowing and understanding Oregon laws and administrative rules relating to notarizations. Non-attorney notaries must not give legal advice, prepare documents, or finish drafting documents for their clients. This can be seen as practicing law. The Secretary of State's office is available for questions by phone, email, or in person. The Secretary of State's office offers notary seminars, maintains a website, and publishes a notary guide. It's up to each individual to make use of these resources and to make sure you understand what is required. Let's briefly touch on the term Notario Publico. Notaries in foreign countries have vastly different powers and functions from notaries in the state of Oregon. Because of this disparity in duties of notaries in foreign countries, Oregon law prohibits a notary public other than an attorney licensed to practice law may not use the term notario or Notario Publico. A notary who is not authorized to practice law may not advertise or represent that the notary public may help persons in drafting legal records. A non-attorney notary may not give advice on immigrations, legal matters, or practice law. Improper notarization is called misconduct. Misconduct can be either intentional or unintentional. If a notary public signs and applies their stamp to a certificate without completing the certificate, it is considered official misconduct. The signature and stamp are the last steps in the notarization process. Intentional misconduct is when a notary deliberately or intentionally tries to defraud the signer of a document. It is deliberate disobedience of notarial statute, rule, or best practices, often done to defraud the signer of a document. Unintentional misconduct is when the notary makes a mistake. It wasn't a deliberate intent to defraud someone. It's when an error or mistake was made. One area the notary has complete control of during the notarization is the certificate. The certificate must be filled out completely, and it should always be truthful and accurate. An example of unintentional misconduct would be if a notary forgot to apply an impression of their stamp on the certificate. This wasn't done deliberately, it was a mistake the notary made. If the customer has the notary correct the certificate, the notary should also put a note in their journal to that effect. The notary should always document in their journal any corrections that have been made to the certificate. The Secretary of State would rather educate than regulate the notary. That's one reason we have an education requirement for new notaries. If you make a mistake as a notary, we will send you an advice letter explaining the error that was made, the correct procedure, and also include the statute or rule governing the procedure. Criminal penalties can occur when deliberate disobedience to statute or rules occur. Civil penalties can occur through either intentional or unintentional errors causing damage. The notary can be held liable for damages that occur through an improper notarization. How can a notary protect themselves from lawsuits? Reasonable care is the standard notaries must follow. What would a reasonable person do under those circumstances? Would they refuse to perform the notarization because the signer didn't have proper identification or their identification was long expired? Is the document obviously fraudulent? Reasonable care is what judges throughout the country have traditionally held notaries to. But along with reasonable care, the notary needs to obey the laws and rules that govern notarizations. There are many situations the notary public will encounter that are not precisely spelled out in law. The law gives general guidelines but relies on the notary's common sense to properly evaluate each situation. For example, notaries may use a driver's license to identify a signer. But if the ID looks false, such as a tampered photo, obviously incorrect birth date, etc., the notary has a duty to act appropriately. When you use reasonable care by obeying the laws and rules and using your good judgment and common sense to perform notarizations, you will stay out of trouble. Applying all of these together is the notary's best defense against liability. Error and omission insurance may be purchased through an insurance company. Bonding may be obtained through a bonding agent. The Oregon Notary Public may purchase one or both of these, but isn't required to. Errors and omission insurance covers the notary should the notary be sued. Most policies don't go over $50,000. The errors and omission insurance will only cover what the insurance company believes is accidental or negligent misconduct. There is also bonding which the notary can purchase. Again, these are optional in Oregon. So it's up to the notary if they want to purchase errors and omission insurance or to be bonded. You would need to contact your insurance company or bonding agent about those. Sometimes documents are created electronically and notarized electronically. The stamp, image, and signature of the notary are electronically affixed to the document. Before you can begin to notarize electronically, you must notify the Secretary of State of the kind of electronic notarization format used. This format must conform to the National Electronic Notarization Standards. You will need to fill out and submit an electronic notarization notice form available on the Secretary of State's website, along with an electronic image of your stamp and signature you will be using. Increasing international commerce has made foreign language document notarization more common. A notary public who fluently reads and writes a language may notarize the signature on a document written in that language. The notarization takes place in the same way as any other, but the notary should note the foreign language factor in their notarial journal. The notarial certificate may be in any language the notary can read and write. Several problems can arise when notarizing a document in a language the notary cannot read. For instance, the notary may be unable to get accurate data for the journal. The notary may be unable to complete the notarial certificate correctly because they cannot follow the certificate's instructions. The notary may be unable to detect blatant frauds. It is for these reasons the Secretary of State recommends that a notary public should not notarize a document or use a notarial certificate written in a language they cannot read. When in doubt, a notary can always refuse to notarize and refer the customer to a bilingual notary. These can be found at consulates and embassies, in an ethnic community, at universities and community colleges, performing a search on the web, and sometimes in the Yellow Pages. It's also a good idea to familiarize yourself with your surrounding area. There may be a notary just down the street that knows a foreign language you can refer your customer to. In summary, a notary is commissioned by the state of Oregon to act as an impartial witness on the state's behalf. Therefore, they must be a person of proven integrity. The notary is responsible for knowing and obeying Oregon laws and rules that pertain to the function of a notary. The notary represents the state, not the employer. You must use reasonable care in performing your duties to protect yourself against any penalties. Errors and omission insurance may be obtained but is not required. And finally, the notary must be able to read and write in the language of the documents and certificates they are using. For further information, please consult the notary resource aids located on our website, or contact the Corporation Division at 503-986-2200.